Well, first of all, just let me thank Professors Yole and Kalman for hosting this wonderful event, and to the staff and fellows of the MCC for such generous hosting. It's an honour, as always, to be here. In the classical natural law tradition, as expounded in recent times by the likes of Professor John Finnis, Professor Richard Eakins, indeed our very own Professor Yole, the adjudication of rights instruments is structured by reference to several core ideas. One idea is that the appropriate role of the judge in adjudicating disputes is to resolve legal disputes by discerning the reasoned choice and intent of the lawmaker, certainly not to engage in prospective rulemaking for the community. The other core idea is the notion that human rights, as specified in posited law, are based on fundamental truths about the ends and goods genuinely constitutive of human flourishing, and not based on what, for example, judges feel is needed to respect individual autonomy or self-determination. So it's fair to say that the picture of the natural law tradition is in some tension with the courts, the European Court of Human Rights' dominant approach as sketched by our previous speakers. And for some jurists, particularly of the natural law tradition, the appropriate response to the cumulative weight of these developments is to simply disengage from the Convention, or perhaps to treat the judgments of the Strasbourg Court as non-binding insofar as they are considered to go beyond the propositions agreed by the signatory states. In these remarks, however, I want to address a more immediate question. How should lawyers committed to the classical natural law tradition engage with Strasbourg's jurisprudence right here and now in their capacity as officials, advisors, litigators? Given that this body of jurisprudence has very significant legal and political impact in the day-to-day institutional play of the treaty signatory states, it's not a question that can be safely deferred or postponed in the hope that structural reform will be forthcoming. And I seek to offer some tentative answers in my remarks via a real-life case study, which is the tenure of the Attorney General for Northern Ireland, John Larkin, KC. Now, I should say John Larkin is actually in the audience, but I wrote this paper before I knew he would be one of the keynote speakers. So if I get anything wildly wrong, John will be there to clear it up, fortunately. So John Larkin was Attorney General for Northern Ireland, which is part of the United Kingdom, but which has its own devolved regional institutions with quite a lot of legislative autonomy. As Attorney General, Larkin juggled a variety of statutory duties. He had to advise the Northern Irish government on matters of law, represent it in litigation, appoint amicus curiae to assist courts on important points of law, all with an overarching duty to act in a way that supported and maintained the rule of law and the public interest. And he had a duty to discharge all his functions independent of political direction. So Northern Ireland incorporates the European Convention on Human Rights. All legislation passed by its assembly must be consistent with the European Convention on Human Rights. So engaging with jurisprudence of the Strasbourg Court was an important aspect of his role. And I'm going to walk through several cases handled by Larkin in his tenure to show that how he deployed the various tools and powers of his office to argue forcefully before several different forums, Northern Irish courts, the UK Supreme Court, the European Court of Human Rights, to argue against unprincipled expansions of Strasbourg jurisprudence beyond the text and reasonably discernible intent of the treaty, and to uphold rights genuinely critical to human flourishing, like the right to life and religious freedom. So I'll outline several of these cases and then talk about how what lessons we should draw from them. So the first case I want to talk about came in 2013, case of X and Austria. This concerned a challenge to an Austrian law, an adoption law that permitted married and unmarried heterosexual couples to apply for adoption, but didn't extend that entitlement to unmarried same-sex couples. And this was challenged as a breach of Article 8, privacy, in conjunction with Article 14, discrimination. So Larkin intervened on his own motion on behalf of Northern Ireland to make several submissions for the benefit of the court. At the same time, back in Northern Ireland, there was a domestic challenge being brought to Northern Ireland's adoption legislation, so the judgment of the court in Strasbourg would be very important to resolve that. The starting point for Larkin's submissions was to begin with the text and reasoned intent of Article 8 which he argued simply did not extend to a right for non-married couples to adopt. This was just not within the intended scope of Article 8. He further submitted that, in any event, the domestic legislature was better than the European judge to assess questions concerning the notion of family, marriage, and the relations between parents and children. And he further submitted that the Austrian law was based on the reasonable supposition that the best interests of the child lay with its legislative status quo, that an adoptee should be placed with a mother and a father. So the court accepted, in many respects, the thrust of these submissions. The court accepted that there was no obligation under Article 8, in fact, to extend the right to adoption to unmarried couples at all, whether they be same-sex or heterosexual. So it was successful on this point. However, the court did go on to say that if a member state does decide to extend a right to adoption beyond the married family, then they must give pressing justification why they're not extending it to both unmarried same-sex and different-sex couples. And the Austrian court thought that Austria did not give that kind of convincing justification. But on that main point about the scope of Article 8 covering the right to adoption, that submission was successful. And as I said, around the same time, the Northern Irish Human Rights Commission, which is a public body like the Hungarian Ombudsman charged with enforcing human rights, they brought a full frontal challenge to Northern Ireland's own statutory criteria for adoption. Northern Ireland at that stage was the only part of the United Kingdom which restricted the ability to apply for adoption to the traditional married family. In his submissions, so this challenge was brought, and that Larkin, as Attorney General, intervened to uphold the status quo. The High Court sided with the Commission and said that the legislation was incompatible at first instance, and Larkin aided in the appeal. In his submissions to the Court of Appeal, the Attorney General submitted the criteria in the impugned legislation restricting adoption to the traditional married family were lawful, appropriate, had the support of the Northern Irish Assembly, and were in the best interests of children. And he further argued that pursuant to Strasbourg jurisprudence, there was simply no Article 8 entitlement to apply for adoption beyond the traditional married family, and therefore the court should defer to the legislature's position that prospective adoptive households should structure the family structure which delivers the best outcome for children, which the attorney argued was the marital family headed by a man and a woman. And he argued, in the absence of clear and consistent Strasbourg jurisprudence, deference was warranted. The attorney's problem actually was not Strasbourg's jurisprudence, but a prior decision of the House of Lords in the UK that interpreted the Convention and the scope of Article 8 much more expansively than Strasbourg had. In a case from 2008, the Law Lords had rejected and held incompatible with the Convention a restriction of adoption to married couples. The attorney stressed to the Court of Appeal that this was a mishandling of Strasbourg jurisprudence by the House of Lords and tried to confine it to the specific facts of that case. However, the Court of Appeal in Northern Ireland felt bound to side ultimately with the House of Lords' expansive interpretation of the Convention, which went further, as I say, than the Strasbourg Court itself. So the court, following the House of Lords, said it's irrational, contrary to the Convention, to restrict a right to apply for adoption to the married family. You must make it available to unmarried couples, and therefore, if you make it available to unmarried couples, the ex in Austria requirement to restrict it to opposite-sex couples means you have to give very pressing justification, which the court felt was not forthcoming. So while these submissions were ultimately unsuccessful in this particular case, I think that they serve a few valuable secondary pedagogical functions, which I'll talk about at the end. More successful was a case from 2016 after the Northern Ireland Assembly introduced an amendment criminalising the purchase of sex. They introduced the Nordic model to regulate prostitution, and this was made it the only region in the UK to do so. An applicant sought leave to bring judicial review proceedings to strike this legislation down on the grounds it was an interference and breach of her Article 8 right, her privacy right to engage in prostitution, to engage in sex for hire. So judicial review in the UK, 2 stages. You have a first stage where you need to show you have a modest chance of success, and then you can bring full proceedings and argue on the merits. So the attorney intervened at the early stage to say the court should deny proceedings be brought whatsoever. Now, the court did grant the applicant permission to bring full proceedings, but because they were satisfied they passed the threshold of modest chance of success. However, the court noted when granting leave the, quote, considerable force, end quote, of Larkin's submissions that the scope of Article 8 of the Convention really did not seem to cover in any way an entitlement to engage in sex for hire. In other words, even at this early stage, the court saw force in the argument it wouldn't need to proceed to proportionality review of the impugned legislation because Article 8's scope did not even extend prima facie to an entitlement to engage in prostitution. Ultimately, this case was discontinued and did not reach a hearing on the merits, and this legislation remains on the books today. 2016 also saw the attorney intervene in multiple stages of the Lee and Asher's Bakery Company religious liberty saga. This case, Asher's concerned proceedings brought by Northern Ireland's Equality Commission against owners of the Asher's Baking Company for breach of anti-discrimination law. Proceedings were brought after the owners of the bakery refused to bake a cake for a gay rights activist bearing the slogan "Support Gay Marriage" and with a cartoon of Bert and Ernie on it. At the time, gay marriage was actually not permitted in Northern Ireland, and the owners of the bakery were Orthodox Christians who didn't support its legalisation. They refused to process the order, they gave a refund, and they said, this has got nothing to do with your orientation, this is just about we don't want to endorse something contrary to our religious beliefs. However, the Equalities Commission brought proceedings under anti-discrimination legislation on the grounds that it was against sexual orientation, and the owners were ultimately fined. There was a civil penalty inflicted, and the penalty was upheld by a court at first instance. The attorney intervened in support of the applicants in appealing this fine. The attorney intervened at both the Northern Ireland Court of Appeal stage and ultimately right up to the Supreme Court stage. And the attorney's submissions at both stages was that the issue for the defendants was one of compelled speech in being forced to supply the message on the cake contrary to freedom of thought, conscience, freedom of religion, basically Article 9 and 10 rights. Those Article 9 and 10 rights were simply given no weight whatsoever by the Commission in their interpretation and their enforcement of the anti-discrimination legislation at issue. The Court of Appeal found against the bakers, but at the Supreme Court, the attorney submissions and the applicant submissions were successful. The Supreme Court said that the respect due to the applicant's convention rights to religious freedom and conscience meant that the anti-discrimination legislation should not be read or given effect to in such a way as to compel providers of goods like the bakers compel them to express a message with which they disagree with on good faith religious grounds unless pressing justification could be shown to require it, in which none was offered in that case. So in the end, the bakers were successful, and that's a very important landmark for religious liberty in the UK. Around the same time, we saw in Northern Ireland a full frontal challenge to Northern Ireland's laws on marriage, which, like Hungary's at the moment, define marriage as between a man and a woman. So this was a challenge to that on Article 8 and Article 14 grounds. Again, the attorney intervened on his own initiative to defend the status quo. And he emphasised again, Article 8 had nothing to do with marriage. Article 12 expressly deals with marriage. Article 8 had nothing to do with it, not within the scope. So he argued that the High Court in this area of sensitive policy should apply a very deferential framework in assessing the state's justification for upholding a traditional conception of marriage. And this was successful at the High Court level. However, it was appealed, and the Court of Appeal, in a remarkable judgment, rejected all claims for judicial deference to the legislature's decision in this area, and engaged in a very searching and intensive proportionality review. And they framed the legislation somewhat dismissively as trying to balance personal rights on the one hand with tradition, as if it was rights versus mere sentiment or prejudice. And so ultimately the court found a balance was not struck, and they didn't in the end declare the legislation incompatible because in any event Westminster in the UK opted to legislate directly for gay marriage in Northern Ireland over the heads of the repeated rejections of the Northern Irish Assembly. In the final case I'll talk about, again around this time, around 2017-18, a case was heard after the Human Rights Commission in Northern Ireland began a legal challenge against Northern Ireland's pro-life legislative framework. Northern Ireland at that stage was the only part of the United Kingdom to have a very rigorous protection for the unborn. And this challenge brought by the Commission argued that this framework was contrary to Article 8 because it did not provide for legislative exceptions to allow for abortion where the unborn had a serious life-limiting condition or was conceived through sexual violence. So the attorney intervened in this case again to uphold the status quo at the Court of Appeal. His preliminary submission was that there was actually no standing for the Commission to bring these proceedings because it was a public body and it actually suffered no breach of the European Convention in any event. But the attorney submitted, in addition, that as with previous cases, Article 8, by its text, intent, and by precedent of Strasbourg, did not extend prima facie to an entitlement to access abortion services in the circumstances forming the basis of the Commission's complaint. And finally, the attorney said if legislation was found to engage Article 8 prima facie, there was a very strong proportionate justification, namely the protection of the unborn and the right to life. The case worked its way to the Supreme Court. The attorney won on the procedural point. The court found that the Commission did not have standing to bring proceedings and therefore they wouldn't give the declaration of incompatibility. However, on the substantive ground, the Supreme Court went further than Strasbourg in its interpretation of the scope of Article 8 and found that Northern Ireland's regime was inconsistent with the Convention. In doing so, they engaged in quite an intrusive proportionality review and expressed scepticism of arguments that the protection of the life of the unborn was justified and legitimate because the unborn enjoys intrinsic worth regardless of how it was conceived. And some on the Supreme Court went so far as to say that Northern Ireland's rigorous protection of the unborn was a breach of Article 3, which prohibits inhumane, degrading treatment. So while the attorney's submissions failed on the substantive point, his successful procedural objection that the Commission had no standing meant the Supreme Court did not issue a declaration of incompatibility, invalidating legislation, and this ensured that important restrictions protecting the unborn would stay in place for several more years in Northern Ireland, until eventually the Westminster Parliament again legislated directly to introduce a liberal abortion regime. Those are the cases. What to make of Larkin's tenure in light of them? Well, I suggest they reflect the fact he took very seriously his statutory duty to uphold the rule of law by regularly intervening to advance sound interpretations of the Convention, more consistent with its text and reasonably discernible intent. As well, I think, is more consistent with human rights properly understood in light of their ultimate source, natural law and human dignity. So I think natural law jurists, anyway, can take at least two lessons away. First, those with influence over governmental litigation strategy or policy should proactively engage where possible and prudent to ensure adjudicatory bodies applying supranational jurisprudence are presented with submissions offering the best account possible of the applicable law that best reflects the reasoned choices of the signatories to the 1950 Convention and strongly resist any unprincipled expansion and de facto amendment of its terms. So being proactive not only includes engaging with forums that are directly relevant to one's own jurisdiction, like the Northern Irish courts in Larkin's instance, but to other forums where a convention law may be developing, where one has an entitlement to seek to intervene and make submissions and influence proceedings. So in Larkin's case, this meant making submissions at all stages of the Northern Irish courts, before the UK Supreme Court and the Strasbourg Court itself. One might reasonably interject at this stage and ask, well, what was the point in many of these interventions if they were ultimately unsuccessful? What was the use in trying if political actors ultimately imposed things like abortion and gay marriage in Northern Ireland, partly by leveraging aggressively broad interpretations of the Convention that went beyond Strasbourg jurisprudence even? So my response to this would be that even if Larkin's interventions were unsuccessful in proceedings, or if successful arguments were ultimately overridden, making the foregoing arguments serves two other important functions. First, it's a way of bearing authentic witness to important and true principles important to the political common good, like the rule of law, and anchoring the content and scope of rights in human dignity, which I think has an intrinsic value and useful pedagogical function. Second, I think doing so has an important indirect pedagogical function. For some, Larkin's tenure might serve to sharpen arguments for disengaging more completely from Strasbourg jurisprudence and the European Court's jurisdiction. If courts, both home and abroad, regularly act to make de facto amendments to the treaty via judicial lawmaking, amendments which are often not conducive to genuine human rights and goods, then I think the intelligibility of binding ourselves to the treaty and its commitments dissipates very considerably.